thank you so much for being here. We are going to talk first, when I've done this presentation for about, 8, 9, 10 years now, we always start by talking about Minnesota's juvenile justice system, just the basics, right? So that we all are sort of generally on the same page about what we're talking about. And then after that, we're going to talk about our office's approach and what we're doing here as it relates to youth justice. Oh, right. Okay. This is a new clicker for me, so I'm going to do my best here. So an overview of our youth justice system, and I'm hoping you all will engage with me on this. Anybody know what's the youngest age at which a child can be charged in juvenile court in Minnesota? And if you don't know, you can guess. Yes? 14? No, it's actually 10, but the international standard is 14. So here in Minnesota, the youngest age of juvenile court jurisdiction is 10, meaning you can be charged with a delinquency, held in custody in a locked facility at the age of 10. Internationally, the standard is 14, so that's a very well-educated guess. When I started practicing in Boston, the age was 7, and out there, I believe it's 12 now. Okay, so this might be a little bit easier. At what age does juvenile court jurisdiction end? Yes.
19 or less EJJ up to 21.
Correct, right. So once you turn 18 in Minnesota, you can be charged, when you get charged with an offense, it's in adult court. But juvenile court jurisdiction, meaning the amount of time in which the court has control over a young person, ends at 19 for the vast majority of cases, which we call delinquency cases, and 21 if it's EJJ, and we'll talk about what that means. Also, please interrupt me. I'm standing here at this podium, but I'm really hoping we can have a dialogue. So, in Minnesota, we have 4 types of charges: petty misdemeanor, misdemeanor, gross misdemeanor, and felony. And I'm wondering if anybody can define any of these terms in the context of the juvenile justice system. Any guesses? Like, what's a misdemeanor? Okay. Yes, go ahead. Right, well, that's a perfect lead into my point, right? So actually, the definition is the same. So misdemeanors up to 90 days. Gross misdemeanor just changed to be up to 364 days because of immigration consequences connected to that. Felony is a year or more. But in the context of the juvenile justice system in Minnesota, these words have meaning, but they don't have the same impact. So if I was an adult and I was charged with a 5th degree assault, and I just didn't want to deal with my case anymore, and I said, I'm just going to take my time. Give me my 90 days, which would end up being 60 days. I'll plead guilty. I'll take my time. That's not possible in the juvenile justice system. So if you are 13 years old and you're charged with a 5th degree assault, anybody remember how long does the court have jurisdiction over kids? 19. So in theory, the court could continue its jurisdiction until that child turned 19. In practice, that's not generally what happens. In general, for misdemeanors, it's usually like about a year or less. Felonies, ideally, it's 2 years or less. But these limits don't exist, and there is no mechanism by which a child can say, just give me my time and I will be done. They must participate in the system and work through their probation or their placement or what have you in order to complete and have the court's jurisdiction end. Does that make sense? It's important to think about, because in a minute, we're going to talk about some of the due process protections that kids have versus adults. And I think it's important to remember the severity of the consequences that kids can face. So mentioned this a little bit earlier, but there's 3 types of cases: delinquency cases, which is the vast majority of cases in juvenile court; EJJ, which stands for Extended Jurisdiction Juvenile; and adult certification. And we're going to talk about those more in a little bit here. But I think it's important to talk about some system decision points, because this comes into play later as well. So the first decision point, as it relates to youth being brought into the justice system per se is a citation or arrest. And I have this question on here, why does this matter? And what I want you to understand and remember from this is that this is the point at which records are created. This is the point at which records are created. And it's going to become important in a few slides, and we're going to talk about why. The next potential decision point is, can this child have pre-charge diversion? That can be done by law enforcement, police, or through our office, and both of those exist here in Hennepin County. We have a very robust pre-charge diversion program at the Hennepin County Attorney's Office, and some of our law enforcement partners do as well. I spent a lot of time working with Minneapolis Police Department on their community restorative diversion for youth. If the charge is not diverted pre-charge, then there's a first appearance. This is when there can be a detention decision, meaning is the child going to be held in custody or is the child going to be released? And they can be just released or they can be released on electronic home monitoring, which is that ankle bracelet that you might be familiar with. We don't have bail in our juvenile court system. So it's either you're held or you're released. That's it. After the first, yes.
Just a quick question.
Yeah.
What is the benefit of pre-charge diversion when it comes to records?
It avoids the creation of court records, which is important. It's complicated. This is a complicated discussion point. But court records, particularly for kids who are 16 or 17 and charged with a felony, those are public records. So simply being charged with a felony, regardless if it's later dismissed or reduced to a misdemeanor, it's a public hearing and a public record, which means folks can get access to that. And we're going to talk more about that in a minute. Court records also have other potential impacts on a young person. So it is a really important decision point, and also that citation or arrest is really important too. So we'll come back to it. Thanks, Perry. So then there's, this should say post-charge diversion and pretrial court dates, right? So there is this opportunity for something called post-charge diversion, which is in Hennepin County Juvenile Court, comes off as a continuance without prosecution, essentially means the case gets continued for a year, stay out of trouble, follow through on whatever it is you agree to do, and the case is dismissed. There's no adjudication, there's no admission on the record. The other things that happen at these pretrial court dates, discovery, motions like RAS motions, motions to suppress. We don't have the time to get into the level of detail that's required, but I want you to generally understand the process. And then the last point, of course, if we get here is a trial. And then, does anybody know if youth get a jury trial in Minnesota? I'm seeing head shake. No, that is correct. Kids do not get jury trials here except if it's EJJ or adult certification. This is not consistent across the United States. When I practiced, again, when I was out in Boston, kids did get jury trials. And so, there's some really important due process protections that are encompassed within a jury trial. You've got folks in this room who have practiced as lawyers, and I think I would tell you, and I suspect they would tell you the same thing, that a jury trial is a very different procedural protection than a bench trial, a trial in front of a judge. If you are asking, if you're saying we're going to go to trial in front of a jury, the preparation and what's involved with that and the risk involved with that on both sides is really different. And I think it's an important protection for young people, especially, again, thinking back to what we talked about earlier. Kids don't have the opportunity to just take their time and be done with their case, right? And so we're sort of chipping away at due process protections by saying you don't get to have a jury trial. Yes?
Do you know what the prevalence is like across the United States? Does it weigh heavier one way?
I don't know the answer to that. If I was going to guess, I would say probably more prevalent not to, but I don't.
I think about 10 states have it.
Okay. Thank you, Perry. There was a time it was considered here. If you go down to the Juvenile Justice Center, their courtrooms are set up with juries, and Jean can tell us more about that if folks are interested. But there was a proposal.
And as executive director of the County Attorneys Association, Jean helped defeat that proposal.
So Jean and I every year have a dialogue about jury trials for kids. And anyway. Yeah. Okay. So anyhow, moving to dispositions. So dispositions is how do we resolve the case, okay? And there's a variety. So I already told you about pre-charge diversion. Again, that can be police or county attorney. And I should define diversion. Diversion is sort of an off-ramp, right? It's a way to be exited out of the formal system processing to a community-based program, variety of programs. And we'll talk later, but actually diversion is found to be very, very effective, particularly for youth. So that's the first option. And then I talked earlier about post-charge diversion, which is that continuance without prosecution. There's a stay of adjudication. I'm going to explain to you what that means. Are folks familiar with a stay of adjudication? I'm seeing some heads nod. So important thing about stay of adjudication for our purposes. You have to make an admission and waive your right to a trial, okay? So any adjudication has two parts. Part one is you go into court and you say, my name's Sarah, I admit I did this, and I'm giving up my rights to a trial and all the associated rights. It's longer and more complicated than that, but that gives you the idea. And then part two is the judge says, I accept your admission and your waiver of your rights, and I'm going to put a delinquency adjudication or in adult court, a guilty finding on your record. With a stay of adjudication, you do part one. So you admit you did it, and you waive your right to a jury trial, or to a trial. In juvenile court, there's no jury. But you don't do part two. The judge says, okay, I accept your admission and your waiver, but I'm not going to adjudicate you delinquent. I'm going to put you on probation. And for kids, that can be up to a year, 2 6-month periods. And if you do everything you need to do, at the end of that time, the case will be dismissed. But if you don't, you already waived your right to a trial, you already admitted you did this, and so we can go through a procedure to adjudicate you delinquent. The next disposition is a delinquency adjudication, so you do part 1 and 2 that I just talked about. And then there's EJJ and adult disposition. So EJJ is our blended sentencing model where you get a juvenile court disposition with a stayed adult prison sentence hanging over your head that you have to complete your EJJ probation, which can include stays at Red Wing, our correctional facility for children, and be successful until you turn 21. Otherwise, you face the imposition of your adult sentence. And then an adult disposition is just like any other adult disposition.
Sir?
Yes.
Can a judge give a stay over the county attorney's objection, or is that not?
Yes, and that's different in juvenile court than adult court, so thanks for pointing that out. In juvenile court, a judge can grant a stay of adjudication over a prosecutor's objection. In adult court, they cannot. And I put this up here so you see this line about there being no delinquent finding. This is an important line, and people feel strongly about this, but there are real limitations to what this actually accomplishes for folks. In my opinion, some of the most important things that it accomplishes by being above that line, one is for kids who are facing criminal sexual conduct charges. Minnesota has mandatory predatory offender registration if you're adjudicated delinquent. And there's strong consensus that that is really problematic. So a stay of adjudication on a criminal sexual conduct case does avoid that predatory offender registration. Also, a stay of adjudication avoids the consequence of having to give your DNA, like a swab, to put in the state DNA database. But it doesn't avoid a lot of the other consequences. And I think there's a lot of misunderstanding about this, even when I was practicing in court, that folks who are practicing, there's often a thought that if your case gets dismissed after a stay of adjudication, it was as if it never happened. And that is very far from the truth. Okay, so briefly about EJJ and adult certification. As I said earlier, EJJ is extended jurisdiction juvenile. It's kind of a mouthful and hard to say quickly. it's a juvenile court disposition with a state adult sentence, and the juvenile court has jurisdiction until age 21. Anybody know how old you have to be to get EJJ? I'll give you a hint. You were right when you answered the question earlier. 14. So kids ages 14 to 17 can be subject to EJJ. And then adult certification is the case is transferred to adult court with adult sentencing options. Any guesses on how old you have to be certified?
Is that also 14?
It is also 14. So we're talking about kids ages 14 to 17, and then what types of charges. It's easiest if we look at the statute. So extended jurisdiction juvenile is covered by Minnesota Statute 260B.130. These always have to be felony offenses. And then there's 3 different ways that this can happen. So 14 to 17, a certification hearing is held, and instead of being certified, the court says you get EJJ. 16 or 17, and then you have committed an alleged offense for which you would be presumptively committed to prison if you were an adult. So there's a sentencing guidelines grid, and what the ones that are shaded in, I believe, are the ones that are presumptive commits, and those are the ones where if you're 16 or 17, and then a prosecutor's office can designate it EJJ. You don't even need the judge to do it. And then the third one is you're 14 to 17, the prosecutor requested it, made a motion for EJJ, a hearing is held, and the court agreed that it should be EJJ. For certification, this is Minnesota Statute 260B.125. And there's 2 types of certification. There's presumptive certification and non-presumptive certification. So this is subdivision 3 deals with presumptive certification. This is for kids who were 16 or 17 at the time, and they engage in a felony offense that is either a presumptive commit or they're using, brandishing, displaying, threatening with a firearm. And what's important about this is that the burden is on the child to rebut the presumption by clear and convincing evidence that the case should stay in juvenile court to serve public safety. Yes.
Do other states do that differently?
Yes. Yes.
So not every state has a presumptive certification.
Correct. A lot of states, this is sort of transfer laws. A lot of states have very different approaches to this. And there's a lot of movement around the country to reform this work. Both saying that kids as young as 14 should not be subject to adult certification, that in and of itself is developmentally problematic, but also under what circumstances and how do we decide? And certainly this concept of presumptive certification is problematic because it assumes that the child needs to be treated as an adult, when all the science and evidence that we're going to talk about in a few minutes here says that our presumption should be to treat kids as kids. So there's also non-presumptive certification, and that's for kids 14 to 17, and that's when the burden is on the prosecutor to prove by clear and convincing evidence that keeping the case in juvenile court doesn't serve public safety. And so then what do we mean by public safety? Well, the legislature has laid out 6 public safety factors. You can see them on the screen. So seriousness of the offense and any aggravating factors recognized by the sentencing guidelines, culpability of the child in the offense itself, their prior record of delinquency, their programming history, including their willingness to participate meaningfully in available programming previously, the adequacy of the punishment or programming available in the juvenile justice system, and the disposition options available for the child. And they're required to give the court, when they're making this decision, is required to give greater weight to the seriousness of the offense and their prior record of delinquency than any other factor. These factors, first of all, this statute is very old. These factors don't account for the things that we have learned over time about adolescent brain development and the science behind that. And, they also don't account for prior record of delinquency, often is a result of over-policing of our Black and brown communities, right? And so these factors are problematic, but this is what we have, and this is what the court makes decisions based off of. Other states have made really significant efforts to change what are the factors that they're looking at.
Question. So number 4, the child's programming history, including the child's past willingness to participate meaningfully in available programming. I've had the experience on task forces in Minnesota that instead of serving as a mitigating factor when considering whether the child is either has reduced culpability or is amenable to rehabilitation, participation in past programming, in other words, a child who's been involved in child protection cases, seems to be treated as an aggravating factor, which to me has always been counterintuitive. I'm wondering if you could say a word or two about that.
Yeah, I think that
And in very real, does everyone understand what that means in very real terms?
so I think it can be really problematic because it punishes kids for whom participation in system-ordered programming has been ineffective, or where there's rightfully a lot of distrust with BIPOC communities with our systems, right? Our child protection system, our delinquency system. And so this factor in and of itself can be read to say that if you have been offered opportunities to participate in other programs and haven't taken advantage of that, by taking advantage of that meaning been successful in that, willingly engaged in that, right? And willing engagement looks really different when you're coming from a BIPOC community who's been historically harmed by systems, right? And so it can be used in that way, and I have also seen that.
So Sarah,
Yeah.
in terms of certification, how often do you think, do you have any idea statewide of the non-presumptive certifications? Does that happen commonly, or is that?
I can't speak statewide. I know they're collecting some data on it. I can say here, more often than not, it's presumptive certification cases.
Number 5, the adequacy of punishment or programming feels like it would punish children who are from communities with fewer resources. Is that the case in your experience?
I think it could be. I think the biggest issue with that, quite honestly, is the age. And so if a kid is 16 when the offense happens, and then, we see this with delayed reports, like it doesn't get reported, particularly in like the context of a criminal sexual conduct case. If a kid is really young, even like 14 or 15 when this happened, the case doesn't get reported for 5 years, then it gets reviewed and charged, which takes some time. And by the time it's resolved, they're 19, 20. Well, delinquency is not an option anymore because that jurisdiction ends at 19. EJJ might be an option, but if they're 20 or 21, it's going to be adult certification. And that's really more where we see that come into play. That's a good question.
One thing I'd add to that is, the adequacy of programming in the juvenile justice system. It's kind of a catch-22, right? So if there isn't adequate programming in the juvenile justice system, in part it's because the very folks who authorized this statute and enumerated these factors may not have funded adequate programming in the juvenile justice system.
Well, I think a good example of that is something we're dealing with right now, and that's being dealt with across the state, is there's Red Wing Correctional Center or facility. It's the state's youth prison, but it's only for male identifying youth. And so when you have a female identifying youth who's engaging in behaviors, like if they're on EJJ probation and they're having continued struggles in other placements, we've seen this come up several times where the report back recommends that their EJJ be revoked and that they be certified because there is no equivalent option for female identifying youth.
So where do they go?
Shakopee.
And then they're housed with adult.
So that's something that Mary and I have been working on, and trying to take a different approach to that. So that's the basic overview of our juvenile court system in Minnesota, but I want to talk a little bit about the impact and then the disparities. So question, true or false? All juvenile records are private. I'm seeing heads shake no. So it's false. They are not all private. How about this one? Juvenile records are expunged or erased once the youth turns 18. I can't tell you how many times this question and this assumption was made when I was meeting with kids and families when I worked at the Legal Rights Center. This is also false. So juvenile records definitely do not disappear, and some records are public. I mentioned this earlier. So 16 and 17-year-olds who are simply charged with a felony have a public hearing and a public record. And what that means is that private data miners, like if you've ever Google searched your own name or a name of a friend, and it's like, do you want to know the criminal history of this person, right? Click on this link. Those companies send private data miners down to the court, and they sit at the court, like the little portals, data portals, because 16 and 17-year-old records are public, but they're not available online through the court system. So you actually have to go down to the court physically and use the data terminal to get it. But they send people there with laptops, and they just sit and they enter the information into those databases. And so then it does become widely disseminated on the internet. And then it's also important to know that even private juvenile records can impact a young person's future. So state agencies and organizations have statutory access to records. I'm going to give you an example of one in a minute here. Okay, here's an important one. The only records that can negatively impact a youth are records of adjudications or convictions. I'm seeing folks' heads shake no, right? You're getting the theme here. Also false. So we're going to talk about that more in a minute here, but records can impact lots of things. Employment, housing for that young person and their family, education, ability to participate in military service, immigration, driver's licenses, and a lot of other things. So I want to talk specifically about one collateral consequence that has a huge impact here in Minnesota, which is Department of Human Services disqualification. Sorry, there's a typo on that. So in Minnesota, you have to do a DHS background study to provide direct care to vulnerable people. Anybody have a guess of like, what does that mean? What types of jobs are we talking about here?
Nurses.
Sure, nurses have a slightly different licensing, but same general idea, right? PCAs, but also the folks in the facility who do janitorial service, right? Also the folks who do cafeteria service in like a nursing home. So we're talking, so vulnerable people, young people, the elderly, sick folks, direct care, any person who could interact with them in any capacity. Again, janitorial service, including janitorial service and, cafeteria type service. So what types of cases result in a disqualification and for how long? Any guesses? What do you think should result in a disqualification?
Person crimes.
Person crimes, okay. For sure. And for how long?
I feel terrible because I've actually seen this presentation, but I'm forgetting exactly how long. I would say maybe, I guess what might be optimistic, but 10 years.
Okay. So it's 7 years for a misdemeanor level. So misdemeanor theft, assault, receiving stolen property. And just to give you clarity on that, like a misdemeanor assault is like a 5th degree assault, like kids getting in a fight at school, no weapons involved, no serious injuries. Misdemeanor theft is a very low level theft.
So you're saying even a juvenile adjudication for misdemeanor theft?
We're going to get there. It's 10 years if it's a gross misdemeanor. So it's the same if it's a gross misdemeanor theft, a gross misdemeanor assault, receiving stolen property, possession of burglary tools, it's 10 years. 15 years if it's a felony. Same as above, right? So a felony theft is if it's over $1,000. Felony drug offenses. Threats of violence. We have no threats charge in Minnesota that's not a felony. Lots of others. And then there's permanent disqualifications for things like aggravated robbery, criminal sexual conduct, including aiding and abetting an aggravated robbery. So to get to what Perry was asking us about, does a person have to be convicted or found guilty or adjudicated delinquent to be disqualified? No. So what types of records can result in disqualification? So for this, it can stem from just an arrest or a citation, even if the case is later dismissed. And the standard of proof that they use at DHS is preponderance of the evidence, which means it's like slightly more than 50% chance of being true. This applies exactly the same to kids as it does adults. There's no difference between a 10-year-old and a 50-year-old. It's exactly the same. How many background studies do they do in any given year? Between 250,000 and 500,000. And these can impact things like jobs that I told you about, but also adoption, being a foster parent, volunteering, internships. It has a wide reach. And this is just one collateral consequence of the records that are created by bringing folks into the system. And again, we're not even talking about adjudications. We're talking about the arrest or citation record. So that leads me to talk briefly about disparities, because I think these things go hand in hand. Who are we doing this to? So there's this thing called disproportionate minority contact. It's something that's talked about in the field of youth justice. And it basically says that disparities occur at decision points throughout the juvenile justice system. And so I'm not going to read them to you. You can see all those different points. But it's important to know that youth of color can be overrepresented at certain decision points, most decision points, and underrepresented at others. So, for example, you're going to see, we're going to talk about the arrest decision point. Youth of color are significantly overrepresented. But when it comes to a decision about, is a youth going to get community-based probation, community-based diversion versus like a secure confinement, youth of color are underrepresented in those decisions, right? And so that's why we call it disproportionate minority contact, because it's not always an overrepresentation. So this is the most recent data I had access to, 2019 Minnesota youth population by race, ages 10 to 17, because those are the kids that are eligible to be brought into the youth justice system. You can see this is the percent of youth. So 71% of youth were white in 2019, 11% black, and so on. And now what you can see is the comparison between the population data and the percentage of delinquency arrests. So in 2019, white youth made up 71% of the population, but just 47% of the delinquency arrests. Black youth made up 11% of the population, but 35% of the delinquency arrests, and so on. Another way of looking at this is something that we called relative rate indices. It's sort of complicated to explain, but essentially it's solving for the rate. If white youth were solved for at the rate of 1, at what rate are other categories of youth, racial categories, arrested? So in 2010, black youth were arrested at over 6 times the rate of their white peers. In 2019, it was closer to 5 times, like 4 something. So you can see there have been some improvements, not for our Hispanic or Latino population, but there have been some improvements, but not nearly enough, right? It's still hugely, hugely disproportionate. And so that leads to the question, why does it matter, right? I mean, there's the ethics of it, right? Justice, equity, community, all of the moral, equity, values-based reasons. But also, I just want to come back to this slide here when I talk to you about that DHS disqualification, right? This is based on an arrest. It's based on an arrest that we're disqualifying people from being able to pass a DHS background study. And this affects a huge portion of the population. And when we think about who are we arresting and bringing into our youth justice system, we're mostly impacting Black and brown communities, right? So there's a ripple effect from these disparities. Okay, so that's the overview of our youth justice system. And now I want to talk a little bit about what is our approach and how are we approaching this work. But first, let me pause and see if you have any questions.
I have 2 questions. One is, maybe we'll start with the broader question, or I guess the more detailed one is, on a daily basis, we deal with the difference between like major juvenile traffic offenders and regular juvenile offenses. And so I wanted to know if there's a way to kind of clarify how those interact, because I don't see the same distinction in adult court. But if there is like a substantive difference in the way that those are treated once you reach the adjudication phase.
I'm not sure I totally understand your question, if I'm being honest.
We work in the traffic clinic.
Sure.
So we're dealing frequently with kids who are adjudicated major traffic offenders, and it seems to put them in like a different track. And I was wondering if,
I think those are petty offenses,
okay.
is my understanding. I could be wrong on that. No, they're not.
Well, yeah, we deal with a lot of like misdemeanors, but then it's,
Okay.
yeah, kind of is a different.
I don't know the answer to, what's that? I don't know the answer to that. I know that there's a traffic calendar in juvenile court, but I'm sorry, I don't know the answer to that question.
I mean, that's totally fine, and I could definitely probably find an answer to it. I was just, but the second piece is, can you talk a little bit about the various dispositions available at the adjudication level and like how those are determined?
Yes, and I'm sorry because I've been supposed to be repeating the question so that people can hear. So the dispositions available at the adjudication stage can include probation, which could be supervised or unsupervised, and it has terms of probation, and those could range from community service, letter of apology, mental health treatment, substance abuse treatment, and terms of probation can also include an out-of-home placement. And for youth, again, just as I said earlier, it's not generally a time-limited out-of-home placement. Usually it's based on progress in whatever the treatment is that's happening there. And then up to and including a placement at Red Wing, which is the state's juvenile prison.
Is there a presumption against incarceration, or if the child hasn't had the opportunity to be out on conditional release prior?
So the question is there a presumption against incarceration for young people? Yes, in Minnesota Statute 260B, which sort of governs this, there's a strong presumption for what they call the least restrictive alternative. Okay. Other questions, or I'm going to go on to our approach. Okay. So I'm going to invite Mary to jump in here with me whenever she feels like she wants to do that. But our approach is really about taking an evidence-based youth development approach, right? And this is, as Perry mentioned earlier, taking a youth development approach is not antithetical to improving community safety. In fact, they go hand in hand. They're deeply intertwined. So first, I thought I'd just start and talk with you a little bit about the research and evidence that suggests that what we've been doing in our youth justice system for decades does not work. So some negative impacts just generally of youth justice system involvement. Increased risk of future system involvement. Study after study after study shows that the deeper you go into the youth justice system, the more likely you are to recidivate, to be arrested again for more serious offenses. School disengagement and poor education outcomes. So kids who come into the youth justice system are much less likely to attend school, to graduate, and to go on to, sort of more productive careers or education. Really poor health outcomes. This is a new-ish emerging area, but there's a lot of research coming out that suggests that really poor health outcomes associated with youth justice system involvement. This is really important. Disconnection from community supports. Everything that we know about young people, and we're going to talk more about this later, suggests that young people need to be surrounded by community-based supports in order to thrive and be successful, and that we need to wrap supports and services around young people in community spaces so that they can be successful. And justice system involvement is inherently isolating and disconnecting. And then it's also super expensive, really, really expensive with really poor outcomes. And so I will send you this PowerPoint, and each of those links at the bottom are resources that speak to some of these points. From the Office of Juvenile Justice and Delinquency Prevention, from the Justice Policy Institute. These are really valuable resources to take a look at in this area. I also brought for you a copy of a research paper that was done on diversion work in Minneapolis Police Diversion by partners over at the University of Minnesota Healthy Youth Development Prevention Research Center. And I brought it for you because it talks specifically about work that's happening in our community and really focuses on findings that what is a better approach. But I wanted to highlight a couple of things from that report and the citations for each of those. So first, law enforcement contact during adolescence is associated with a 3-fold risk of being arrested as a young adult. So again, as I said earlier, significant increased risk of future recidivism by being brought into the system at that point of law enforcement contact.
Does that particular paper talk about, did the authors theorize why that might be the case?
Probably, but you're going to see there's so many research reports. So for this specific one, I can't speak to exactly what they said, but I'd be glad to get it for you. Yes. Punitive accountability that relies on sanctions imposed by an authority figure, for example, a judge, with whom a young person has no relationship, is likely to engender defiance and other negative attitudes rather than behavior change. We know this, right? Anybody who's ever been a kid, ever been around a kid, knows that it's much more effective to do things with young people than to impose on young people. In addition to being an attorney, I've been a restorative practitioner for over a decade. And so I had a long time of having a front row seat both to the youth justice system and to restorative practices. And restorative practices are hands down more effective. And there's a lot of research coming out to show that at this point. But anecdotally, from my perspective, this is fundamentally because all people, but particularly young people, are more accountable to relationships than they are to rules any day. And restorative practices is about relationships. When we bring young people into a system where they're identified by a case number, where it's set up just to process large numbers of folks through, it's not identifying and not building relationships in that space. And then, this one's really important, that our juvenile criminal legal system is set up in a way that believes that some youth are just simply not treatable. And in fact, there is actually no science showing that there's no level of risk that signifies that somebody's beyond help. And I'm not gonna undervalue the importance of, like, if somebody murders somebody, they've taken a life that can't come back, right? It is different in that way. And we honor and we know that. And also we have an accountability to community safety, which says that we have a responsibility that when it's possible to try to rehabilitate. I mean, that is the point of our youth justice system. And we are taking an evidence-based approach that says we have, that gives us the best possible chance of doing that. The very clear reality is nobody has a crystal ball. Nobody can look into the future and say, if you do this, then this. All we can do is make evidence-based decisions based on the best research and evidence available to us about what is going to be most effective. And what that evidence tells us is that the way that we've done things in the past actually makes us less safe.
Is there any international research that supports that conclusion?
Absolutely. I mean, and there's research. I mean, I'm going to cite more of that in a minute here, but there's a lot of research that says sending kids to adult prison actually makes our communities less safe because they're significantly more likely to recidivate. And so there's a lot of research that supports the fact that if we try and use the approach that we're about to talk about, that we are more likely to improve community safety. Again, no crystal balls. No one can predict the future. But if we are looking at the data, and if we're serious about rehabilitation, and if we're really serious about community safety, not just saying community safety, public safety, but if we're actually serious about community safety, what we need to do is look at what's going to give us the best chance of rehabilitating folks. And so that because people re-enter our community, and so that when they do, they're successful and not repeating behaviors. And that's what we're trying to accomplish here.
One thing I'd add to that just is that there are only a handful of other countries in the Western world that not only, virtually none, prosecute children as adults, but very few actually even prosecute 18 to 21-year-olds as adults. Most other Western countries are way ahead of us, not just in sort of the age 18 binary of treating children as children, but it's Latvia, Belarus, and three other countries that don't have separate juvenile facilities for emerging adults. That's how far behind we are. And the recidivism rates, and my criminal law students may remember this. We looked at some other country comparisons last year. The recidivism rates for people coming out of those facilities are incredibly low. I mean, less than 5%.
And I can tell you that doesn't align with our recidivism rates and the impact on young people who are incarcerated in adult facilities as children. So speaking of youth incarceration, I wanted to share a little bit about what we know about the negative impacts of youth incarceration. So when we're talking about incarceration, we're talking about separating a young person from their family, from their community for some period of time. And sometimes this is necessary to protect community safety because that young person cannot be safe in their community. But we need to, if we're gonna do it, we need to be really mindful of the harm that we're causing when we do it. So again, increased risk of recidivism, disconnection from family, support networks, and community. This is really, really important. In Hennepin County, we don't have the spaces that we need for young people who cannot safely be at home. And so we send kids out of state. We send kids down to Red Wing, which is, I don't know, what was it, an hour and a half when we went down there recently. These are not places where young people can stay connected with their family and with their community and build community networks of support. They're going to come back to community. And all the evidence suggests that when they do from these places that are outside of community, it's really ineffective and they're more likely to recidivate. Decreased likelihood of graduating from high school. So again, really negative educational outcomes. There's a really significant risk of physical and sexual abuse. I linked to a report in here from the Casey Foundation about maltreatment of youth in U.S. juvenile correctional facilities. You may have recently even just seen the report that came out about what happened to a young person at Ramsey County Juvenile Detention Center. There were a couple reports earlier this year from Red Wing. Really problematic things happening in these spaces. And again, very, very expensive with poor outcomes. And when I say expensive, I mean, I'm talking about like hundreds, if not over $1,000 per diem, per day for young people. The difference in what we pay to educate a young person, I don't have the most updated numbers. We spend over $100,000, I think it's closer to $110,000 to incarcerate a young person at Red Wing for 1 year. And we pay close to $14,000 or $15,000 to educate a young person for 1 year. Think about the difference between that. Think about what we could do with that money if we wrapped it around young people in their communities. Okay, so our approach to youth justice takes all of this into account, right? We know that there are times we have to send young people to someplace other than their home because they cannot safely be at home, but we are actively advocating for things to look different. And so, general overview, we want to improve community safety and well-being through both individual and system accountability that leads to positive outcomes for youth, families, and our communities, while also simultaneously centering victims and their healing. These things are not separate. They're deeply intertwined. We're using a positive youth development approach, which I'm going to talk more about in a minute here. It's all grounded in youth developmental science and research, and it recognizes that children are children. They are not little adults. So what is positive youth development? If you Google it, you can learn a lot about it. It's essentially an intentional pro-social approach. It's focused on engaging youth within their communities, within their schools, organization, peer groups, and families, places where they already are, right? Natural support networks. And it's focused on supporting them in a manner that's productive and constructive, that recognizes their inherent value and strengths, and promotes positive outcomes, right? So it's about building on positive outcomes, building on positive strengths. And again, some links here for research if you're interested. How does this fit within a youth development approach? So science is very, very clear. Human brains are generally not fully formed until your mid-20s. And that among the last parts of the brain to fully develop is the prefrontal cortex. That's the area of the brain that impacts a lot of important functions, particularly related to decision making. So everything that we're doing here is grounded in this youth development approach and grounded in understanding that kids' brains are not fully developed. In 2013, the National Research Council put out a report about taking a developmental approach and highlighted 3 ways that adolescents are different from adults. 1, less able to regulate their own behavior in emotionally charged contexts, more sensitive to external influence such as peers and the immediacy of rewards, and less able to make informed decisions that require consideration of long-term consequences. These are really critical ways that young people are different than adults. And I would encourage you to read any of these resources that are linked on here. And then lastly, I just want to point out, fundamental our approach is that kids are kids, children are children. They are not little adults. We've talked about this a little bit, but what we are trying to do in all of our work is to focus on understanding the science and engaging in practices and interventions that leverage that science to impact behavior to have the best possible outcome for communities, for families, for young people. I said this earlier, but certifying children as adults has been demonstrated to have a negative impact on community safety and youth. So youth charged as adults are 34% more likely to be rearrested than their peers who are treated in the juvenile justice system, and that's national research. So I could probably spend our entire time talking about any one of these slides, but that's why I linked research on each of these so that you could have an opportunity to dig deeper into the things that are of interest to you. So how does this play out? Like, what does this actually look like for us? Is there anything you wanted to add there? Okay, so a couple of things that I think are really important to our approach that you're going to see throughout everything that we do here. We know that interventions with youth are most effective when they're immediate, so as close as possible in time to the behavior. Think about that for a minute. If a young person is 15 and they have some incident that happens that can bring them into the court system, and it takes months before they ever get before a judge. I mean, it can take months. They're kind of like, that was like a whole era ago for a 15-year-old, right? I mean, months passing, a new school year, like they've moved on. And we are waiting through our traditional process, waiting a really long time, 6 months, a year, sometimes longer, after the initial incident happened before we're putting interventions in place. That's way too long. Anybody who works with young people will tell you have to have immediacy in your interventions. It also needs to be relational.
Control that, Sarah.
How do you control that?
Prosecutor, so how do you dictate that?
I'm going to show you what we're doing.
All of us are going to slow that down.
Yeah, I'm going to show you what we're doing to do that, because I'm going to give you some really specific examples of the ways that we're trying to do that. We don't get to control everything. But there are things within our sphere of control, our sphere of decision making, and then I think about this as what's within our sphere of decision making and then what's within our sphere of influence, right? And so we're doing the things that we can within our sphere of decision making and then working with partners within our sphere of influence to implement this approach. We also know interventions with youth are most effective when they're relational. So accountability to those most impacted. Our system does a terrible job of supporting people who have been harmed, victims. And what we know is that, the historical approach to saying, sort of keeping victims on the side and just sort of saying at the end, you can give a victim impact statement, does not actually move the dial for the victim, and it also doesn't do anything for the young person who engaged in the behavior that caused harm, right? So what we want to do is have accountability that centers the impact of our victims and their healing by engaging in a relational approach which restorative justice allows us to do. Going back to what I had said earlier, but I think this point is really important, so I'm going to say it again. But young people in particular are more accountable to relationships than they are to rules. So if what we care about is changing behavior, interventions focused on changing behavior, we need to do that with folks that they can have relationship with, right? And I think if you think about it, this applies in your own life too, right? Like a random rule versus somebody that you have a relationship with, which one are you going to be more accountable to? And particularly young people, right? And where they're at with their brain development. Yeah.
What do you say to someone that says, two things. One is, you have victims' family members who are saying, you want to center me in this conversation. I'm telling you, what I want is for them to, the people who did this to my loved one to go away and to
They want
never come back.
retribution. Right.
So that's number one. But number two, so that's the retributive argument. Well, what about the deterrent argument? What about the argument that by just giving the proverbial slap on the wrist to a defendant, you are effectively saying to other young people, go ahead and do what you want. There are not going to be consequences. I'm assuming you.
So our colleague Jen White, the director of our Community Affairs Division, joined us late, but we are so lucky to have her on our team. And she's building out our restorative justice work within the office. And so one of the responses back to, first of all, victims are not a monolith, right?
Exactly.
So the loudest voices that you may be hearing more recently are folks who are unhappy with, in the way Mary's described, right? Like we're not following through on this sort of idea of justice being really long prison sentences. But there are people who are supportive, right? And there are victims who actually what they want is for this not to happen to somebody again, right? And the best chance that we have to accomplish that is rehabilitation. But also, how do we center healing? Well, we need to be able to build out our ability and our capacity as an office to support restorative practices for victims who are interested in that. But, Mary's been in office for less than a year. Change is hard, and we are working on that, but we are super lucky to have Jen leading that effort, and I feel very confident that within this term, we will have that up and running. I know it's a huge priority for her. And to Mary's point about restorative justice, also just more broadly, is that we actually know that's a really effective intervention because it hits all of these things, right? It can be immediate, relational, individualized, and community-based. So I'm going to keep going down my list here, right? Individualized, accounting for the individualized strengths and need of each youth and family. And so again, that goes back to that positive youth development, the youth development approach, is we need to understand what are the strengths of this young person and their family. And then how can we build on those strengths to address the concerns and the challenges and the needs. And then community-based, so connected to that youth and families community, regardless of the level of services and supports needed. So I want to be really clear about this because there's a lot of folks who think when I say community-based, I mean that all young people can always be safe at home. And I know that that's not true, even though I wish that that was true. We know that there are some young people who cannot safely be at home for one reason or another. But what research has shown us across the country, and this, I think it makes a lot of logical sense, is that when a young person cannot safely be in their home and they need to be live in a different place for a period of time, that place, regardless of the level of security, should be in community. Why? If you think about it, right? Let's say I'm in one of these, I can't safely be at home and I'm living in this, and I'm out in Utah, and I develop relationships, right, with the providers there. I have a therapist there. And then they're like, this is not hypothetical, this is real. We send kids to Utah. I'm in Utah, and I've now developed relationships with my therapist, my providers, what have you. And they say, you have done great. We are going to send you home. And now I'm back in my community, and all of those relationships that I've built have been broken. Remember what I said earlier, more likely to be accountable to relationships than rules. They come back with a bunch of rules, but no relationships. Versus, I can't safely be in my home, and maybe I need to be in a facility that is more secure. But if that is a small space within community where services from community can be wrapped around me in that space, then when I transition home, I can keep the same therapist. I can I can have the same school, right? I can have my same connections to chemical health, mental health treatment, what have you. Those relationships are still intact. And that's why it's a lot more successful. And it's not just me saying this, like I have a whole binder of research in my office if you'd like to read about it. Yes, go ahead.
If anything, we've shut down all the kind of facilities.
So the county homeschool, right, was not effective. I mean, and I think this even goes to like, that's out in like Minnetonka or, sort of way out, right? Right, but the thing is, for me, that's not a big deal. I can hop in my car, I can go there. But for the young people and families that we're talking about who are super vulnerable, who don't have access to transportation, who don't have stable housing, who don't have who don't have stable employment, that's a huge barrier. Even that 20, 30-minute drive is a barrier. And so when I say in community, I don't mean in the far reaches of our county. I mean like literally in the communities where our young people and families lived who are most likely to be impacted, right? And this is what, I just want to say, this is what other states across the country have done and done really effectively. And it significantly reduces recidivism, because one of the biggest points of challenge for a kid is most kids do really well in a placement. Undoubtedly, you know that, right? They do really well and then they transition home and it all falls apart. And if we can make that transition less of a transition and more of a supported handoff because you're in the same community, it makes a lot of logical sense and the research supports it.
Is there anybody working on?
Yes, we're working on it. Us and some county partners. I know you had a question.
Yeah, I was just curious if you could talk more about like the Utah thing and just kind of piqued my curiosity. What like prompts that? And
It's the deny from all the local places that will not accept that young person. Okay, so going back to our youth development approach, this guides all of our work. So what does this look like in practice? And I know, Perry, you were asking about this earlier. We have our youth auto theft early intervention pilot, which is a great example of how we're trying to put these concepts into practice within areas that we can. So undoubtedly, you have heard that there's a problem in our community as it relates to auto theft, right? And particularly young people as it relates to auto theft. And so when Mary came into office and then I joined her here about a month later, we sat down and said, what is within our control? Because here's what we know. Auto theft cases across the board have very low clearance rates, meaning they are solved at a very low rate by police, which means we don't get a lot of cases. 2%? So 2% of reported auto thefts are cleared or solved, okay? So that means 98% are not. And so when we met with our law enforcement partners about this, what they said was, well, we know who the kids are who are involved. We just can't prove it yet. These are cases that are really difficult to prove. And so what we said is, okay, what we're going to do is create a new early intervention pathway outside of the legal system for voluntary interventions for youth who are engaging in auto theft related behaviors, who our partners are saying, these are the kids who are in the car, who are always hanging around, who we know are part of this, but we can't prove a case against them. And then we're going to work with our partners. So remember I said sphere of our decision making, that's point one here. We can make a choice to do this. Point two is working with our partners to shift practices within the legal system to offer earlier supports. Can you just shut that? Thank you. Okay, so what does part one look like? The new pathway for voluntary supports. This is outside of the legal system. It's entirely voluntary. It's a collaboration across this Children and Families Division. Mary and her leadership created the Children and Families Division. It did not exist here before. So I oversee our youth prosecution, child protection, Be at School, which is our truancy work, and our child support work. So this is a collaboration across the whole division that engages in one-way information sharing with law enforcement. They share information with us. They don't submit cases. They don't have cases to submit. We meet with them once a week and they tell us about kids who they are concerned are engaging in auto theft related behaviors. And they tell us why they're concerned about it. These are not just hypothetical concerns, but what is the evidence that you have to suggest that this young person is engaging in behaviors? We have committed, we are not using this information to criminalize young people. Instead, we're using it to offer voluntary opportunities for support. And so what this looks like in practice is the referral comes into us. We do a file clearance to see, are they already open in youth prosecution or child protection or truancy? If so, they get routed to those folks to say, hey, this is on the radar, not to criminalize, just to say, we are not going to send it to this voluntary pathway. They're already system involved. If we clear the case, yes.
I ask you a digressing question.
Well, let me finish this and then I'll come back. If they're not system involved yet, we refer the case to a social worker who does outreach to the family. At first, when we started this pilot, we were doing that in-house with our Be It School social workers. And since then, we've developed a partnership with our behavioral health partners who have social workers embedded in local police precincts. And so, let me just see. Okay. This was my attempt with Sarah Shaw, who's not here anymore, to sort of map this out. What does this look like? So if you look at the left side of the screen, this is the system that it currently exists. This is our legal system, right? If there's sufficient evidence to charge, you can divert it, you can send it to us, we could divert it, we could charge it. And each of those blue boxes on the left side, or circles, I guess, are places where there's opportunities for intervention. But if you look on the right side where there's not sufficient evidence to charge, notice that it's blank because there's nothing there. So what this pilot does is it says, okay, if you don't have sufficient evidence to charge, we're going to build out all of these new ways that young people and families can get connected into systems of support. And I didn't put the slides on here, but what we have found is every family that we've reached, so we started this in June, so we looked at data through the summer. We're going to pull fall data soon, but every family that we reached acknowledged the concern. They were not surprised and actually grateful to be hearing and to have this opportunity to connect. This Family Response Stabilization Service, FRSS, is this great program that the county has where they can get a person on site within 1 hour anywhere in the county to respond to a crisis, however that's defined by the family. So we've been making a lot of referrals through that program. Enforcement diversion, and then we're collaborating with system partners for expedited charging decisions in court hearings. So some young people come into the JDC and get released. They're being seen by a judge within 3 days, which means we're making a decision within 2 days. And then we worked with our partners in the Department of Corrections to DOCCR to put in place voluntary pretrial supports for youth who are facing auto theft charges. Because what we know is the recidivism rate for youth auto theft charges for young people alleged to have engaged in auto theft behavior is significantly higher than other categories of cases. And so we are trying to live our values, right? And live our approach, which says earlier accountability, earlier access to services and supports that's relational. So this is the big map that we put together, and all the things in red boxes show all the new things that we put in place. And this was all put in place by June. So we worked pretty quickly on this from when we started. And I'm not going to spend a lot of time walking through this, but to your point earlier, Perry, what can we do? We have to be creative about the things that we can do, but we have to be accountable to earlier, quicker interventions that are relational, that are community-based. We are trying to live that as well in the spaces that we have access to. And then I thought we could talk a few minutes about our shifting approaches to EJJ and adult certification. Mary talked a little bit about one case, and I think that's the case that I had suggested to Perry that she send out. So I don't know if folks read the Minnesota Supreme Court decision on that. Okay, so there's a Minnesota Supreme Court decision on it that Perry can send around and that you all can read if you're interested. But, you know, you're undoubtedly also seeing this play out in the media as well. And so I just wanted to open a dialogue and a discussion about what are we doing, right? We know that we're limited. We are limited by the fact that we only have court jurisdiction over most kids until they turn 19, EJJ till 21. And so it's challenging, right? Because kids engage in behaviors that cause serious harms because they have had a lot of trauma also in their own lives and have a lot of treatment needs. And sometimes when you are seeing us say, okay, we are going to certify or we are going to use EJJ, it's because we need more time. Our partners in DOCCR have created a new unit for 18 to 24-year-olds that's housed out of their juvenile unit, right? And so there is change happening, and we are aligned with that. And I think what you're seeing, and hopefully what you've seen in these last discussion slides, is that we're taking an approach that says our best shot at community safety is to follow the evidence in the research, which says that sending young people to prison makes them more likely to come out and recidivate and have more serious offenses. And if we provide the treatment and supports that they need, they're more likely to be successful. Again, no crystal ball. We're doing our best to make educated decisions about what's going to keep folks safe and keep this from happening again. But I want to be really clear, like it's, in this case, it's not that we're saying our offer is that you go on probation and you just, best of luck to you. Like there's significant adult prison time hanging over your head if you're not successful and you can't follow through. And that's the case in all of these cases, right? It's about giving folks an opportunity at the rehabilitation, at the treatment. And if you can't follow through on that, then you are facing significant prison time. And so that is sort of the middle ground here, right? But I think a lot of that gets lost in the narrative, in the media narrative about what we're doing. We have another case, 2 young people who were 17 at the time, and that there was a drug deal gone bad, and everybody fired shots, and another person ended up dead. And we are certifying one of the 2, and we're seeking EJJ on the other one. And I think it really illustrates the why, right? Because they were both 17, so we're really reaching the edge of what we have for time. But one of them's been through has an extensive history, has been through extensive treatment, including Red Wing, right? And has come out and still done the same things, right? Now, if we had until they were 24, we might be having a different conversation, but we only have until you're 21, versus the other one who has an extensive trauma history and no prior history, no prior treatment for any of that trauma. And to treat them exactly the same because they were involved in the same incident does not take this youth development approach, does not take this scientific evidence-based approach about what's most likely to keep us safe, right? Because incarceration is incapacitation, right? And sometimes there is a period of time within which a person cannot safely be in community. And we know that most young people age out of offending behaviors, right? Once their brain fully develops in their mid-20s. But in that case, you have a young person who was not able to demonstrate being able to, go through treatment and be safe in community afterwards, and we're running out of time, versus a young person who has not had any opportunity to engage in any of the treatment that they need. And even in that young person's case with EJJ, they have a very lengthy adult prison sentence. So again, I take issue with the idea that this is a slap on the wrist. It's just simply not. Going to Red Wing for 2 years, like Red Wing is a prison for kids. That's not and coming out and having these very significant adult prison sentences hanging over your head, it's not a retributive approach, right? And it doesn't align with the historical idea that the amount of time that you end up in prison, it equates to the value of justice. But justice, in our viewpoint, is about ensuring that this doesn't happen again, right? And that's about community safety, and that's what we're trying to accomplish here.
Do you see your role as kind of mitigating some of the facts that EJJ is not like I'm going to use this in quotes, but like a kid-friendly law, and that it's not aligned with the science? It feels like very much if you violate any of the conditions, you could be revoked, but it doesn't say violate, same or similar, or, so you could essentially end up being revoked, but for like a very small crime. Do you see a role for prosecutors to like mitigate against the way that some of these laws are written?
I'll just say we represent someone who was on EJJ for second-degree homicide, who was revoked like weeks before their 21st birthday for smoking a joint.
In Hennepin County?
Yes, this was.
Oh, years ago.
This was in the 90s.
Yeah. So I think there has been a shift in that, but I do think that the law hasn't changed, but I think there's been a practice shift in that. I do think, I mean, the prosecutors hold huge discretion, right? And I think we have an accountability to use that discretion in a way that's aligned with our goals related to community safety. And so yes, I think there's also a conversation that needs to be had about the statutory framework, and what we're doing in that space. And that's something that the Supreme Court opinion and the concurrences, invited in that, and that we're really looking forward to having with policymakers. I recognize also that because I think class is supposed to end at 5:20 and it's 5:21. So I don't want to be the person that keeps you here longer, but I'm happy to take more questions. Go for it. Yeah.
We've talked a lot about rehabilitative approaches, and I was wondering what sort of your office's position is on, there are a limited class of offenses that qualify for expungement, and what your guys' position is on expungement going forward and plans that you have for that.
Yeah, so it's interesting because actually in juvenile court, for straight juvenile court, all qualify. There's no limits in juvenile court, which is different than adult court. I can tell you expungement is something that we are really interested in on the youth side. I talked earlier about just one collateral consequence, right? And trying to make that administratively easier for folks to access and to support that. We are fortunate, we just got this 3-year grant from the Office of Juvenile Justice and Delinquency Prevention that's going to allow us to do a lot of transformation in our youth justice system. But one of the things we wrote in that we want to work on is expungement. And I'll let Mary speak more broadly for the office.
Yeah, we're in the process of revamping our expungement approach. We have a lawyer who's dedicated to doing that work, and so I've got her first proposal, she's working on it again, and so you'll see a much more expansive approach from us.
Just a follow-up. Does that also apply to thinking about people where you use EJJ or people who are certified as adults?
So you mean people that had been previously certified as adults or EJJ?
Yeah, juveniles who are charged as adults, certified as adults.
I think we will absolutely, I mean, we're going to look at everything. I don't know where we're ultimately going to land, and we haven't dug that deep into it yet. We just got we haven't even signed the grant agreement yet. We just got this grant, but I'm really excited about it.
Theoretically, if we had such a case, who at your office should we contact?
For an expungement?
Just hypothetically.
Hypothetically, that's a really good question. I would send hypothetically that to Sean, and then Sean would figure out where to send it.
Okay.
Actually, probably Mark Osler.
Okay. Hypothetically, you may get any more.
Yes.
I was curious about your general charging decisions and how you not even start this all rolling. What do you decide the process?
Yeah, it's a really good question and something that we're starting to look at and tackle. And I'm excited about the resources that this grant is going to provide us to take an evidence-based approach to that. We just met with our partners from the Healthy Youth Development Prevention Research Center at the University of Minnesota earlier this week. And we're going to be taking an evidence-based approach to look at what, because everything I said earlier, right? When we bring young people into the system, sometimes we have to do that. But when we do that, we have to be aware of the harm that we're causing. And so now we have to address that harm. Looking at like who needs to come into the system, right? Is there a group of types of cases or young people based on evidence and research that we could say, actually, we don't need to take this route? And then looking at diverting. Sometimes we have this, we send kids to like divert to HSPHD, which is human services essentially. And we're really working on building up our partnership there. Like one thing you've probably heard us, if you've followed the news at all, is we've made a commitment that we're really trying hard not to charge kids under the age of 13. So kids 10, 11, and 12. I think maybe 2 or 3 since I've been here. And that's because of a function of problems with getting diagnostic assessments done in community and things like that. But we are actively working on shifting to have different system responses. What we really think is that regardless of how you come to the attention of needing supports and services, that just because you come in one door doesn't mean that your pathway should only be here. But that if you come in this door and it's apparent that what you need is actually over here, it doesn't matter that you came in over here, because we want to get you over here to what it is that you need. And for a lot of young people and families, they don't need delinquency system involvement. Yeah.
My question is also kind of similarly about diversion practices in particular, but which you answered a little bit, but when you're talking about your sphere of influence and how diversion can happen at kind of the police level, have there been things that the office has done recently to try to increase diversion at that level specifically, or like increase awareness about what police officers should be looking for in certain types of youth that are kind of more evidence-based like you're talking about?
Yeah. Yes. So we, Minneapolis Police Department had a very robust youth diversion program, and then during COVID, the numbers dropped significantly, and so we've been working collaboratively with leadership over there to try and reinvest in that. And this research paper that I'm going to give you all before you leave talks about the results of that. It's something I worked a lot on before I came to this office. And so we're working on doing that with other partners, but also something that we're doing that's brand new. Just last month, I think it was in September, we had our first meeting with school leaders. So superintendents and school board members, to talk about our approach and what are we doing and how can we partner with you. And one of the things that we said is that we have contracts with community-based restorative providers. And we would love to make it so that you can access those resources without having to send a kid to the justice system to get there. And so we're early in the stages of doing this, like building these new pathways, but we're doing it, and I feel really excited about it. So I oversee our child protection division. And we are doing a lot of work in that area to collaborate with our client partners. So this is a little bit different. We represent Hennepin County Human Services as a client. That's our role. And so, but we are, I will say there's a commitment from leadership in that area of the county, and commitment from our leadership too, to continue to work in that area and to continue to implement similar values in that work. So I'm mindful that it's 5:30, and I really want to allow people to, it's probably awkward to walk out on the county attorney. So I'm going to end. But this is my contact information. Perry always knows how to get a hold of me by cell phone, and I just appreciate you all coming, taking the time to hang with us.